answer key was published.
My lords, what happened?
Yes.
I'll place the whole thing. CWJC number 1655.
First answer key after expert committee's report has been already published, and the same should be sent to the second expert committee.
But because my objection with BPSC, I had no.
There is no such direction by the High Court to send it to the second expert committee.
No.
Now you are asking me as a judge to examine whether the question was wrong or right.
It's very clear whether the writ court would venture in the exercise. Moreover, in this case, my lord was observing that in first round of writ application,
Was non-suited for selection to the post of lecturer. My lords, in an advertisement number 36 of 2014, issued for appointment of lecturers in Government Polytechnic and Women's Polytechnic College under Science and Technology Department for the stream Civil Engineering. My lords, the petitioner missed his cutoff by 0.09 marks only.
Yes.
My lords, initially when the result was published on 12/12/2018, my lords, the petitioner sent a representation to the commission. Lords, that representation was not considered. Petitioner alleged that at least so far as 4 questions are concerned, the answer key on which the candidates have been evaluated is incorrect. Lords, the commission did not dispose of my representation or did not take any action on my representation. I was constrained to move this honorable court by Annexure 8, page 55. If your lordships will kindly have Annexure 8, page 55.
Where is your objection?
Yes,
Where you raised?
Yes, my lords. That is Annexure 7 at page 49. My lords. If your lordships will kindly see page 50, I had enclosed various authoritative textbooks, etc. in support.
That was when the first answer key was published.
My lords, what happened? They published the provisional answer key. According to me, in the provisional answer key, they had rightly pointed out the correct options. And that was tallying with the options that I had marked in my answer sheet.
All right.
But in the final answer key, they changed the options from C.
Against the final answer key you submitted.
Yes, against the final answer key. So I had no occasion to file an objection against the provisional answer key because my option and according.
Right. Yes.
My lords, kindly come to Annexure 8, page 55. My lords, I am reading the last paragraph. Taking note of my representation, my lords, this honorable court held, considering the fact that representation of the petitioner is pending before the BPSC, the writ petition is disposed of with direction to BPSC to dispose of the representation filed by the petitioner contained in Annexure 5 by a reasoned speaking order within a period of 60 days from the receipt of production of a copy of this order. Now kindly see what is the order they passed. That is Annexure 9, page 57. This was also passed only after I filed a contempt petition. Kindly come to page 58. If I can just point out the gist of what this order says. This order says, my lords, कि ये final answer की,
आप पढ़ लीजिए ना.
I'll place the whole thing. CWJC number 1655/18 में दिनांक 27/8/18 को माननीय उच्च न्यायालय पटना द्वारा पारित आदेश के आलोक में विज्ञापन संख्या 100 दिनांक 16/7/16 को आयोजित की गई थी। परीक्षा के उपरांत प्राश्निकों द्वारा उपलब्ध कराए गए औपबंधिक आदर्श उत्तर आयोग के वेबसाइट पर दिनांक 11/8/16 को अपलोड कर दिनांक 24/8/16 संध्या 5 बजे तक संबंधित उम्मीदवारों से साक्ष्य के साथ आपत्ति सुझाव की मांग की गई थी। उक्त सूचना दिनांक 11/8/16 को दैनिक समाचार पत्रों में आयोग द्वारा प्रकाशित किया गया था। उक्त उत्तर के विरुद्ध 56 उम्मीदवारों द्वारा आपत्ति प्राप्त हुई। विज्ञापन संख्या 36-34 रासायनिक अभियंत्रण विषय के प्रश्न 1 से लेकर 100 तक के वस्तुनिष्ठ प्रश्नों एवं उनके प्राश्निकों द्वारा उपलब्ध उत्तर की शुद्धता की जांच, उम्मीदवारों से प्राप्त सभी आपत्तियों पर विचार एवं आदर्श उत्तर तैयार करने हेतु दिनांक 22/9/16 एवं 28/9/16 को विशेषज्ञ समिति की बैठक आयोग कार्यालय में आहूत की गई। नौदे से विशेषज्ञ समिति में कम से कम 10 वर्षों से अधिक शिक्षण अनुभव प्राप्त अभियंत्रण महाविद्यालय एवं विभिन्न महाविद्यालयों विश्वविद्यालयों के एसोसिएट प्रोफेसर, प्रोफेसर रैंक के कार्यरत तथा सेवानिवृत्त प्राध्यापक शामिल रहे हैं। उक्त बैठक में विशेषज्ञ समिति द्वारा प्राश्निकों से प्राप्त उत्तर एवं उम्मीदवारों से प्राप्त आपत्तियों की विस्तृत रूप से समीक्षा की गई। समीक्षा के उपरांत विशेषज्ञ समिति द्वारा उक्त विषय प्रश्न पुस्तिका श्रृंखला ए के प्रश्न 1 से 100 तक का आदर्श उत्तर तैयार कर आयोग के समक्ष प्रस्तुत किया गया। समिति द्वारा उक्त विषय प्रश्न 1, 4, 11, 19, 47 एवं 79 अर्थात कुल 6 प्रश्नों को सकारण रद्द करने की अनुशंसा की गई। साथ ही समिति द्वारा प्रश्न संख्या 3, 14, 27, 28, 38, 40, 42, 48, 67 एवं 91 के प्राश्निकों से प्राप्त उत्तर को अपने सम्यक रूप से समीक्षोपरांत संशोधित करने की अनुशंसा की गई, जिसे आयोग द्वारा अनुमोदित करते हुए उक्त मॉडल उत्तर के द्वारा परीक्षा फल मूल्यांकन की कार्यवाही की गई है। वादी श्री सतीश कुमार चौधरी द्वारा समर्पित अभिवेदन में अंकित क्वेश्चन बुकलेट डी के प्रश्न 21, 42 एवं 96 जो सीरीज ए का क्वेश्चन 27, 48 एवं 42 के जम्बर्ड क्वेश्चन है के उत्तर भी इन संशोधित किए गए उत्तर में सम्मिलित है। अतः उपरोक्त वर्णित तथ्यों से स्पष्ट है कि प्रासंगिक परीक्षा के लिए आदर्श उत्तर का निर्धारण सम्यक रूप से समीक्षोपरांत विशेषज्ञ समिति द्वारा किया गया, जिसे आयोग द्वारा मान्य किया गया है। उक्त तथ्यों के आलोक में अभिवेदन में प्रश्न 21, 42 एवं 96 के संबंध में अंकित आपत्ति को विशेषज्ञ समिति की अनुशंसा के आलोक में विचारणीय नहीं पाते संचिकास किया जाता है। So they did not consider my representation at all. They said that provisional answer key was revised by an expert committee in which these 3 questions were also revised, and therefore your representation is not worth consideration, notwithstanding the direction in annexure 5 which I just showed to your lordships. Now I filed a contempt petition, my lords. Initially in the contempt petition this honorable court found this order to be contumacious, but kindly see page 59. Kindly see page 59. This court finally had to hold, my lords, having regard to the fact that the matter was examined by expert committee of professors, and thereafter BPSC has finally decided the issue. The court is not inclined to proceed any further in present matter in view of the limited scope under contempt jurisdiction. And my lords, therefore, I had to file the present writ application again. Before I come to that, kindly come to annexure 11. This they had enclosed in the show cause. So far as question number 27 is concerned, my lords, annexure 11, page 60. This is with regard to series A, page 60, annexure 11. Your lordships will find various questions they have discussed, why they changed the option. Question number 27. This corresponds to, my lords may kindly make a note, question 21 of series D, because I have enclosed series D.
Writ petition.
Writ petition, page number 60, annexure 11. Has my lords found question number 27? They have discussed different questions, my lords. Correct option D, whereas setter's option is C. Setter's option will be correct only when P tends to 0, such that NP tends to AM, a finite quantity, and N tends to infinity. So they assigned a reason and they said that this is why we have changed the answer. So therefore, so far as this particular question is concerned, my lords, question 27 of series A, which corresponds to question 21 of series D, my lords, I do not object, because your lordships have held that the weight has to be given to the opinion of the expert. But kindly come to page 61. Kindly come to page 61. Now question number 42. This corresponds to question 96 of series D, and question 48. This corresponds to question 42 of series D. No reasoning is assigned. Correct option is B, whereas setter's option is A. Correct option is B, whereas setter's option is A. Now, I had filed a representation and closed authoritative textbooks to show that A is the correct answer. And your lordships will keep in mind that I have missed my cutoff by 0.09 marks. Each question carried 0.5 marks, even if one of these questions, and they have not assigned any reasons. They have not dealt with my representation. If I may just take your lordships to what the various questions are, I am giving up my claim on question 21 because as per annexure 11 page 60 they have assigned some reason. Let me confine myself to question 42 and question 48 of series A, which corresponds to question 96 and question 42 of series D. If your lordships will kindly come to paragraph 14 page 8 of my writ petition. I have quoted question 42. Kindly see. A beam of length L has my lords got page 8, paragraph 14.
What do you want to show?
My lords, I am showing the question and I am showing the textbooks which I had enclosed in
So
support
you
of.
want us to give you
No,
to
my
check whether the question answer is,
my
which
lords,
one is correct?
My lords, the judgment say, your lordships do not have to enter into this domain.
Or prima facie we have to see.
Yes, I have to discharge that onus. That
And
prima
we have to prima facie satisfy.
Yes, that whether.
That is there, that is the law.
My lords, yes, that is the judgments that I am carrying with me, my lords.
Give us a judgment
Yes, ma'am.
to show that
Yes, yes.
this court is going to look into the question and answer and prima facie be satisfied.
Yeah. And if you're what the judgments that are, yes, kindly see, my lords, 1983, volume 4, SEC 309.
That was Kanpur University.
Yes, I will start with Kanpur University. I have Ranvijay Singh with me, and then, my lords, a judgment of BPSC of 2020 of the Supreme Court, reported in 2020, volume 6, SEC, page 362.
Come to this.
Let me come to 2020, volume 6, SEC, page 362 first. My lords, paragraph 13 and 26. I have given a list of books, if your lordship.
So give me a copy of those judgments which you are having.
Lords, I had given a list of books. The books are here. I'm sorry, my lords, I should have carried printout.
Chalo, chalo.
2020, volume 6, SPC, page 362. 2020, volume 6, SCC, volume 6, SCC, page 362.
Yes.
My lords, let me first place paragraph 13. The court had on 25/9/19 passed the following order. Having heard the learned senior counsel for the parties, we are of the view that the Bihar Public Service Commission should appoint an expert committee consisting of 3 members in order to determine what is the correct answer to the questions which are appended as part of this order. The expert committee will be appointed within a period of 2 weeks from today. The expert committee will submit its report in a sealed cover to this court within a period of 4 weeks from the date on which the committee is formed. The expert committee is left with discretion to co-opt persons of their choice in assisting them. Representations of parties to be submitted within a period of 2 weeks from today, so that committee may consider them as and when it is constituted, list after 6 weeks. Now kindly come to paragraph 26, my lord. So here the Supreme Court, upon being satisfied that the questions required a relook by a fresh set of experts, my lords, directed for constitution of a fresh set of experts. And kindly come to paragraph 26. After noticing Ranvijay Singh, Khushbu Srivastava and other judgments, kindly come to paragraph 26. That your lordships will find at page 376.
What are you waiting for? Argue.
I'm sorry, my lords. I thought your lordships are.
We can
I'm
argue
sorry,
whatever
I'm
you
sorry.
have to argue.
I'm sorry. May I place paragraph 26? Given the clear declaration of law in judgments of this court, we are of the opinion that the unilateral exercise of re-evaluation undertaken by the High Court, both by the single judge and the division bench, has not solved but rather contributed to the chaos. No rule or regulation was shown by any party during the hearing which justified the approach that was adopted. BSSC, in our opinion, acted correctly in the first instance in referring the answers to panel of experts. If there were justifiable doubts about the recommendations of that panel, the least that should have been done was to require BSSC to refer the disputed or doubtful questions to another expert panel. That was not done. The corrections indicated by single judge were accepted by BSSC, several candidates. So therefore, my lords, and paragraph 28 is the direction. The Honorable Supreme Court held that if at all there was justifiable doubts in the mind of the High Court, the least that should have been done was refer those doubtful questions to another panel of experts. So therefore, my lords, I am required to show to your lordships that notwithstanding revision by a panel of experts pursuant to which the impugned final answer key was published, The doubts remain, authoritative textbooks say otherwise, and these questions, your lordships may direct them for a relook or a re-evaluation by another panel of experts. That onus lies very heavy on my head, and I am here to discharge that onus.
That order was not passed in your case when you filed a writ petition earlier.
No, and that because at that point of time, the query of the learned single judge was, did you file any objection? When I pointed out that in the provisional answer key, the options were correctly marked, it is only in the final
That chance was available to you at that time when the court had was hearing your case earlier.
Yes.
That the first answer key after expert committee's report has been already published, and the same should be sent to the second expert committee.
But because my objection with BPSC, I had no
That there is no such direction by the High Court to send it to the second expert committee.
No.
Now you are asking me as a judge to examine whether the question was wrong or right. Which specifically in this case itself, you stopped reading further. That is what the court lamented, that the single judge started going into the questions, and he himself said that these questions are wrong.
Without referring it to the experts, my lord.
That is what they said. So we are not supposed to do that.
My lord, what the High Court had done in Arun Kumar's case, both the single judge and the division bench, the High Court directed that option B should not be the correct option, option C should be the correct option. That is what we are
asking you, Mr. Counsel. When you were taking me to the question and the relevant answer, and so that whether there is a doubt regarding the correct answer or not, that doubt is not required to be seen by us.
Yes, but my lord,
this court is very clear about what is our role, and that role was there when you had filed the petition earlier. You should have insisted upon that there should be a second panel. That has not been directed.
Can I just explain to your lordships? I understand your lordships' observation that what I am arguing today ought to have been argued before in the first round of litigation is what is following from your lordships.
The direction which the court directed,
my lords, yes,
was to examine your representation.
That was not examined. That is what
they have examined it. They said that the questions which you are raising have already been considered by the expert committee, and they have answered.
The dichotomy is this, my lords. The dichotomy is this.
Where is the right in your favor by High Court's order that there should be a second panel of experts?
That was not the direction, my lords. That was not the direction. The direction was.
Neither you are praying that now.
My lords, yes, that is what my prayer is. Kindly see. Kindly see. Prayer B, 1B. May I place that one?
So have you challenged that expert panel to report? Are you? This report annexure 11 and 12, which you just now took us. Have you challenged that?
My lords, kindly see, I have challenged the final result.
You have not challenged that report, huh? That expert report. On the ground either of malice or on non-application of mine. We could have examined that if you had challenged it. Are you getting what this
I understand. Why I have not challenged it is because, my lords, that expert's report is not in public domain. That was filed along with their show cause in the contempt application preferred by me. It is not that.
I don't tell you what was required to be done.
My lords, it is not that expert report they had published on the website and it was in public domain.
All that a petition. Anything else?
My lords, may I just place one more judgment? The Kanpur University case, my lords. Only for the purpose.
All right.
What is required of a candidate before the High Court, my lords.
Yes.
That your lordships, again, my lords, the book is there. 1983, volume 4 SEC, page 309. My lords will find.
Which para you want us to read?
My lords, your lordships will find paragraph 1 is where the issue is recorded with regard to erroneous answer key.
Come to the question of law which they have laid down. Come to that.
May I just indicate, my lords, in paragraph 6 to 14, they noticed all the questions that were impugned and the authoritative textbooks. Now kindly come to paragraph 13, my lords. I'm sorry, my lords, paragraph 15. The findings of High Court raise a question of great importance to the student community. Normally, one would be inclined to the view, especially if one has been a paper setter and an examiner, that the key answer furnished by the paper setter and accepted by the university as correct should not be allowed to be challenged. One way of achieving it is to not publish the answer key at all. If the university had not published the key answer along with the result of the test, no controversy would have been arisen in this case. But that is not a correct way of looking at these matters, which involve the future of hundreds of students who are aspirants for admission to professional courses. If the key answer were kept secret in this case, the remedy would have been worse than the disease, because so many students would have had to suffer injustice in silence. The publication of the key answer has unraveled an unhappy state of affairs to which the university and the state government must find a solution. Their sense of fairness in publishing the key answer has given them an opportunity to have a closer look at the system of examinations which they conduct. What has failed is not the computer but the human system. Now, paragraph 16.
Come to the law which
Paragraph
laid
16.
down.
Yes, my lords. Paragraph 16, the third line. My lords, it starts with, we agree that the key answer should be assumed to be correct unless it is proved to be wrong, and that it should not be held to be wrong by an inferential process of reasoning or by a process of rationalization. It must be clearly demonstrated to be wrong. That is to say, it must be such as no reasonable body of men well versed in the particular subject would regard as correct. The contention of the university is falsified in this case by a large number of acknowledged textbooks which are commonly read by students in UP. These textbooks leave no room for doubt that the answer given by the student is correct and the key answer is incorrect. Now, thereafter, my lords, Ranvijay Singh's judgment. So here also, my lords, the candidate has to demonstrate. My lords, the only forum where I have the option of demonstrating was by filing a representation before the BPSC, which they did not consider. So now I have to demonstrate it before your lordships. Now, kindly come to Ranvijay Singh, my lords, only a few paragraphs of Ranvijay Singh, and thereafter, my lords, I will rest my submissions. My lords, Ranvijay Singh, your lordships will find 2018, volume 2 SCC, page 357. My lords, paragraph 18. After noticing the various precedents, my lords, paragraph 18, your lordships will find at page 363. A complete hands-off or no interference approach was neither suggested in Mukesh Thakur nor has it been suggested in any other decision of this court. The case law developed over the years admits of interference in the results of an examination, but in rare and exceptional situations and to a very limited extent. My lords, then they quote paragraph 19, Kanpur University, and then they say, in other words, the onus is on the candidate to clearly demonstrate that the key answer is incorrect, and that too without any inferential process of reasoning. The burden on the candidate is therefore rather heavy, and the constitutional courts must be extremely cautious in entertaining a plea challenging the correctness of a key answer. To prevent such challenges, this court recommended a few steps to be taken by the examination authorities, and among them are establishing a system of moderation, avoid any ambiguity in questions, including those that might be caused by translation. 3. Prompt decision be taken to exclude the suspect questions and no marks be assigned to it. Finally, come to your lordships, the operative portion, paragraph 30 and 31, because I am aware that my learned senior colleague here would be referring to these two paragraphs. Paragraph 30. The law on the subject is therefore quite clear, and we only propose to highlight a few significant conclusions. They are: A. If a statute, rule, or regulation governing an examination permits the re-evaluation of an answer sheet or scrutiny of an answer sheet as a matter of right, then the authority conducting the examination may permit it. If a statute, rule, or regulation governing an examination does not permit re-evaluation or scrutiny of an answer sheet, as distinct from prohibiting it, then the court may permit re-evaluation or scrutiny only if it is demonstrated very clearly, without inferential process of reasoning or by a process of rationalization, and only in rare or exceptional cases that a material error has been committed. Now, my lords, I pause here. There is a distinction between re-evaluation and scrutiny of my answer sheet and re-evaluation and scrutiny of the answer key, because one is prepared by the candidate while the other is prepared by the examining authority, my lords. So I'm trying to draw that fine distinction here. 3. The court should not at all re-evaluate or scrutinize the answer sheets of a candidate. It has no expertise in the matter, and academic matters are best left to academics. 4th, the court should presume the correctness of the key answer and proceed on that assumption. And 5th, in the event of a doubt, the benefit should go to the examination authority rather than to the candidate. Now, my lords, this has to be read in conjunction with 2020 volume 6 SCC 362, which I just placed, that in case of a doubt, The High Court should not at all enter into re-evaluation. It should constitute another panel of experts to look into those questions, my lords. Finally, paragraph 31. It may be read against me, but my lords, I would rely on the last line. I will place the entire paragraph. On our part, we may add that sympathy or compassion does not play any role in the matter of directing or redirecting re-evaluation of an answer sheet. Again, my lords, they were concerned with re-evaluation of an answer sheet, not with the re-evaluation of an answer key. My lords, at the sake of repetition, my lords, answer sheet is prepared by the candidate, answer key is prepared by the examining authority. So there is a distinction there. If an error is committed by the examination authority, the complete body of candidates suffer. The entire examination process does not deserve to be derailed only because some candidates are disappointed or dissatisfied or perceive some injustice having been caused to them by an erroneous question or an erroneous answer. All the candidates suffer equally, though some might suffer more, but that cannot be helped since mathematical precision is not always possible. This court has shown one way out of an impasse: exclude the suspect or offending questions. Now here, my lords, if the offending questions are excluded, as has been directed in Ranvijay Singh, my lords, the cutoff will be revised. Once those 4 questions go, then the cutoff for all the categories will be revised. I, having missed only by 0.09 marks, I stand a fighting chance, my lords. These are my submissions.
Yes.
My lords, paragraph 32 of Ranvijay Singh judgment makes it very clear whether the writ court would venture in the exercise. Moreover, in this case, my lord was observing that in first round of writ application, he did not raise these issues. He only and there was a direction to consider his representation. That representation has been considered. His only grievance is that while considering his representation, it has not been explained why the question which he pointed out has not been found to be correct. That was not the scope, my lord. His representation has been considered and reasons have been assigned based on opinion given by expert committee which consisted of eminent professors of different engineering college and subject specialists. In the background of, my lord, the opinion of experts, paragraph 32 of Ranvijay Singh judgment becomes very relevant. Whether the writ court would venture, my lord, to undertake that kind of exercise.
Yes.
This judgment and all other judgments have been considered by a division bench of our own High Court, reported, my lords, in 2021 volume 1 PLJR दे दिया हूँ. आप ही का भास किया हुआ है सर, आप ही हालत है. 2021 volume 1 PLJR page 588. Coincidentally, same set of lawyers were appearing in this case also. And the division bench, relying on all previous judgments, including Kanpur University, Ranvijay Singh, Khushbu Singh, has given its opinion in very clear terms. My lord would kindly come to para 60 and 61. In fact, my lords, the division bench also looked into some of the questions with reference to argument advanced by the petitioners. Para 61 is very lucid, which reads an entire argument. Learned counsel for respondents have tried to justify order of learned single judge by submitting that since there is doubt, this is what is being argued here. In the answers, so learned single judge has rightly given direction for revisit of answer by a fresh committee of experts. Whereas law has been settled by Honorable Supreme Court that in such cases, the benefit should go to examining body rather than the candidates. Further, Honorable Supreme Court in Ranvijay Singh case has categorically held that courts should not at all re-evaluate or scrutinize correctness of key answers. As it has no expertise in the matter and academic matters are best left to academicians. The learned single judge has placed reliance on different textbooks cited by original petitioner and held that the same are in acclaimed textbook of respective fields, but the expert committee said the textbook written by so and others referred to by original petitioners are not standard textbooks, and they have considered objection raised by original petitioner and did not accept the same. If this court directs for revisit of answer sheet of those questions, then it is not sure that there will be end of litigation. Rather, in all possibility, there will be further round of litigation, as those who will be affected by revision of result will definitely come before this court, and again, second round and third round of litigation will start. Litigation will not come to an end in near future. The candidates have so and so, and then, my lord. So this is the legal position, my lord.
My lord, just a short reply. Just a short reply. I would like to draw a distinction. What has, again, my lords, in this case, Ashish Kumar Pathak case.
What distinction do you want to draw from this judgment?
Yes, in the Ashish Kumar Pathak case, the petitioners had filed an objection.
Come to para 62.
Yes, my lords. My lords, I have seen that. My learned senior was placing it. I have gone through.
You did not read para 62, so I am asking you to read para 62.
I have the printout of the website. वो 62 उसमें कौन सा वाला paragraph है? Which is the corresponding paragraph?
Judgment. Conclusion.
Conclusion, yes. In view of the aforesaid discussions, we are of the view that the interference by the learned single judge in the report of the expert committee and giving direction for constitution of fresh expert committee to revisit the answer sheet and consequential direction is outside the realm of judicial review. Accordingly, the judgment dated so and so, passed in so and other analogous cases is set aside. The court directs commission to proceed further and declare the results of the main examination if the result is ready. Now, the distinction that I am trying to draw is this. In Ashish Kumar Pathak case, which my learned senior colleague was placing, my lords, the petitioners had objected to the provisional answer key. Those objections were considered, some were not considered, and final answer key was prepared. In my case, the provisional answer key, it is my case that the provisional answer key itself was correct. They were changed to final answer key. I had no...
On their own?
Yes. They had, and I have shown...
It was on their own, or there were some objections relating to that answer key?
But I am not aware. I am
You
not
just now read, Mr. Counsel.
57 objections.
You had read that order.
There were, yes, I have read that order.
Against the representation.
My lords, yes.
Again, when your representation was taken into consideration,
My lords.
the authorities have mentioned that there were 58 objections against the answer key.
And then they
And
had...
therefore, they got it done from an expert committee.
I bow down to that. My lords, facts are not in dispute. I bow down to that.
You are trying to distinguish your case.
Yes. So, my lords, the distinction is this. The direction was to consider my representation and dispose it off by a reasoned order, because I said that the experts had...
Distinction from this judgment.
Yes, my lords.
You are trying to make it distinguishing.
My lords, maybe I'm not able to put it across.
All right, we have heard you. If you have not been able to, we have heard you.
My lords,
Enough.
just allow me 1 minute. May just allow me 1
Okay.
minute.
The petition, by way of district petition.
Can I seek leave, my lord?
Yes, yes. Raise your hand.